actually very excited about this conversation.
Yeah, thanks for having us both. We're really excited to talk on this topic. It's a topic we talk a lot about. I think today's perspective is going to be a little different. You know, a lot of times we're getting in the weeds of Tennessee prenuptial law. And so I think having kind of this elevated conversation about prenuptial agreements in general is a great conversation to have. So.
Yes. Well, Ellen, you wanted to start us off?
Yes, of course. So we are welcoming Catherine and LB, who work at Thompson Burton in Nashville, Tennessee. And to their point, they are licensed in the state of Tennessee, and that's where they practice law. But starting here with a few of the things that we've done today is almost like a 10,000-foot overview. So the first step is really opening the door to education. And then obviously each situation is incredibly different. And we can help you find an attorney that would be best for your fit here. But this is a question, I would say it's one of the more taboo topics
Yes.
sometimes. And so it can be intimidating to even bring up to someone's even like a trusted advisor. And so we're going to start with really doing a general overview and getting into a few more specifics and examples too. So we met Catherine actually at one of our Somerset events in Nashville, Mahjong and Money. She is an associate attorney at Thompson Burton, where she practices family law. She earned her bachelor's degree from the University of Tennessee at Knoxville and her JD from Belmont College of Law. And so she has been at Thompson Burton for her whole career so far. And LB is a partner at Thompson Burton, where she also focuses on complex family law matters. As a skilled Rule 31 mediator, she is able to have that experience too to find client-centered resolutions. So with maybe more collaborative divorce, as we've seen growing in popularity. She also received her JD from Belmont College of Law and serves as a founding member of its alumni council. So we are so honored to have them with us today, and I think we can get started.
Yeah, and I know as Ellen mentioned, this is sometimes a little bit of an awkward conversation for families to have, and we both, I mean, that's part of our job as advisors, is to maybe ask some of the more uncomfortable, hard questions. But this is one that we have, of course, bring up, especially as clients have children that are getting married, or maybe they come to us and say, hey, this has been proposed. I know Ellen has been in prime like wedding season with friends getting married and all sorts of things like that's happening. And so we're really looking for today just kind of hearing like generally like what is a prenup, who needs a prenup, and then just know, for our participants, you can ask questions. There's the chat that's open throughout the conversation. So if you hear anything or you just want to jot down the question so you don't forget, feel free to add it there, and we'll get to it as the discussion continues.
Awesome. We are all in industries that have heavy regulatory, so we have a small disclaimer here, but just kind of starting with the agenda of LB and Catherine, I don't know if you want to start from the top.
Yeah, absolutely. So generally speaking, prenuptial agreements, I mean, most people in this conversation are going to know generally what they are. They're simply just contracts that are entered into between parties who are looking to get married. And so we will touch on postnuptial agreements like briefly a little bit later, but they're just contracts that when the parties, usually when parties get engaged, that's about the time conversation starts happening. That timeline varies from each different circumstance, but they're contracts, and they obviously handle what would happen in the event of a divorce, but a good prenuptial agreement also touches upon death as well, and what would happen in the event of death, and kind of touches on, I know the hour before us was about estate planning, and so it touches on some of that estate planning during the prenuptial process as well.
Yeah, and going off what LB said, not only what a prenuptial agreement is, but in our practice, I think it's becoming, thankfully, a less taboo topic. And so more and more people from different financial or socioeconomic backgrounds are super interested in what a prenuptial agreement may help them do, not only now, but maybe even 20, 30, 40 years from now throughout their marriage. And so we see a large clientele base for prenuptial agreements, whether that be for, the Gen 2 of a family estate or a family office, also for second or third, multiple different marriages previously, as well as just people who are starting off in their careers. They may not have substantial assets now, but they likely will be high income earners later on in their careers. And so they just want to look in the future and be very proactive about protecting those types of financial assets in the future.
That's so true. I think also too, as we touch on next gen and how this intertwines with estate planning, like we had in the previous session, this can be protecting that next gen who could be adults, even if you are, maybe the matriarch or patriarch of your family and the holder of the majority of the assets. So it can apply to more than just, I guess, those starting out.
Yeah. And I have recently had a conversation with someone about a prenuptial agreement, and she said, just due to some family history in the past, she felt nervous about that going into a marriage. And she said it wasn't so much even about like the assets, it was about her peace of mind. Like she just felt like she needed that. She said, I feel like might be distracted by that just as an issue. And I feel like if we can do this from the beginning, I can just rest in it. And it's not something that has to stay in place. If she changed her mind, they could change things. And I just thought that was an interesting way to look at it. She just said, I know myself, and this is something like I really. So sometimes it's like
insurance for your peace of mind,
right? Yeah. Insurance for peace of mind, and it can be as simple as that too.
Yep.
I like to think of them as prenuptial agreements as an opportunity, like an opportunity to start the conversation. It depends. I mean, Catherine touched upon the different people who are coming to us at varying different levels of ages. But when you're talking about the next generation, a lot of times it might be the first conversation you're having with that estate planning or just the life planning component in general. And so it's a great opportunity to have that conversation and for parties in their marriage to have that conversation early on. And so, it is a time when I know personally, Catherine and I, we do quite a few of these a year, and we really use them as an opportunity to counsel clients through that. And to keep tensions low. Where like you're dealing with two parties who are getting married, right? And so it's not an adversarial. When we say the word contract, I think people sometimes who are not part of the legal world or maybe not as versed with contracts, that can cause anxiety or fear in and of itself. And so to come in and say, yeah, but this is a contract that's being handled differently. There's a different approach to this. We're not approaching it adversarial. We're approaching it with you all in mind and your future in mind to try to help build the best foundation for your marriage.
So when people come in to do these agreements, do you also work with them to go ahead and like create a will, power of attorney, etc.? Is it typically done kind of as a package deal?
Yeah, it can be. So, LB and our practice focuses exclusively in family law. And so what that means for us are prenuptial, postnuptial agreements, divorce, and post-divorce. We have a team here at our firm, Thompson Burton, as many firms do, where we work together with estate planning as well. And so sometimes that does consist of either working on a prenuptial agreement and wills and other collateral documents at the same time, or sometimes it's hey, this is a step-by-step process, and some people can only focus on one contract or agreement at a time, and so they have a little more tunnel vision there. But oftentimes we can collaborate with estate attorneys, whether they're already with the family or they need someone to talk about that, and so we can tag team them in if needed, if they want a more comprehensive package.
I love that. And I feel like that kind of like goes to kind of the next piece of it is looking at the construction of really what it entails, which y'all have done a wonderful job of really bringing this out and understanding, the homework you need to do ahead of time, maybe, as you start these conversations.
Yeah. Yeah, and this is in Tennessee, and Catherine and I did do a quick survey of some, Alabama, South Carolina. So we kind of did a little bit of research to look at other states, and I see across the South, it looks like most states have similar requirements. It varies a little bit where people will want to reach out to somebody, but generally this idea of coming to the table fully informed seems to be, you know, across states, a pretty general requirement. It plays out differently, but in Tennessee, you know, a prenuptial agreement it's a full contract. You know, we see really bad prenuptial agreements. And so this would be our plug to wherever you live, and whoever, whether it's you getting a prenuptial agreement or somebody else getting a prenuptial agreement, that internet prenuptial agreements are not generally valid prenuptial agreements. So I say that to say it's a lengthier document typically, right? A lengthier contract because there's a lot of topics to cover. But we require in Tennessee for parties to have full financial disclosure. So again, on that opportunity conversation, you know, it's a great way for parties to come into a marriage informed on finances as well on both sides, and to have that leads to those conversations that you all were talking about, the planning conversations and life planning and estate planning. So in Tennessee, both parties would like we disclose tax returns, 3 years worth of tax returns. We do a full balance sheet, a pretty detailed personal financial statement, and both parties exchange that. We also have where each party needs legal counsel. We make that independent legal counsel where neither party is disadvantaged in the negotiations, because we want both parties walking away from a prenuptial agreement feeling like it's a fair agreement, that they've got security through the agreement, and that's a sense of shared security kind of as they go into their marriage.
Yeah, and I think that's one thing that LB and I both harp on whenever we're drafting these prenuptial agreements and hosting these conversations is it shouldn't be as one-sided as some people may have previously thought prenuptial agreements are, that it's like, hey, one person's gonna, in the event of a divorce, take it all and run, right? And so, like LB said, it's an opportunity for there to be protections on both sides. And so that obviously may look different depending on each party's situation financially and how they envision to have a family potentially and what their workflow may look like in the future. But it's just really, I think, one of the most important topics within prenuptial agreements is to really focus on how each party individually can feel protected, not only signing the prenuptial agreement, right, but going forward and living throughout their marriage. And so along those same lines, there's a few other elements, at least in Tennessee and somewhat similarly across the southeastern U.S. So for consideration, that's essentially just a fancy contract term that means each person has to receive or to give or take, essentially. And so that can mean, you know, a lot of different things. Sometimes, depending on the provisions specifically in our prenuptial agreements, that can mean, you know, a person receives alimony in the event of a divorce, and the other person obviously has to pay alimony. So again, it's just the give and take. Interestingly enough, the other couple provisions that are required for Tennessee prenups are they have to be voluntary. And so that means each party has to voluntarily enter into these agreements, and the terms have to be fair, right? And so that's a pretty broad term depending on the circumstances. But I actually just finished up a 2-day trial last week on hopefully invalidating a postnuptial agreement, because we put forth the arguments that our client, the husband, did not enter into these agreements voluntarily for a whole list of issues. And furthermore, that the agreement itself did not contain very fair terms. In Tennessee, it says it has to shock the conscience. And so for our guy, he actually entered into a postnuptial agreement without legal representation. His wife was represented by an independent attorney at the time, and he agreed to give her, in the event of divorce, 100% of the marital estate, as well as 80% of all income, and other assets he ever earned throughout throughout the rest of his life post-divorce. So obviously our position is those terms are shocking the conscience, and so we're asking that the court invalidate those. So those are just a couple other elements to keep in mind when negotiating and looking at potential terms for prenuptial and postnuptial agreements.
What are some of the most like common provisions that you see that people want in a prenuptial agreement?
So I always say that we, when talking client through, I start with our floor prenuptial agreement. So I'm like, let's just talk about our base prenuptial agreement, which most lawyers I think would have something similar. And our specific one, it's going to be, let's start off keeping everything separate, and then let's tailor what you want together. So let's start with this conversation of, it's just the cleanest way to do it. So let's assume, we talk about assets that you bring into the marriage, their growth during the marriage, their transmutation during the marriage, changing from funds to a house and back again, all of that remains separate. And then income, for purposes of our prenuptial agreement, the one that how we draft it, we usually draft it with income, which is oftentimes people's largest asset that will come into a marriage with them, as separate. Well, you can imagine, for everybody, that's not what they're looking for in a prenuptial agreement. Like, not everybody wants to say, okay, well, we're starting and we're going to be separate forever, and there's never going to be anything that's jointly titled or owned together. So we make sure to build provisions in there that specifically say, the parties still have the opportunity to jointly acquire assets and do it through title and planning and how they use their income and what they put their income into. And so we start, I think, on my approach and Catherine's approach is, let's let our client see a draft of kind of a base prenuptial agreement. And then let's sit down there and talk about different ways. So I have one right now where a client says, I represent the party who might not be asking for the prenuptial agreement, but we're working through it, right? And so she says, I really 100% okay with protecting his premarital assets and protecting his any assets he inherits from his parents, their trusts or anything of that. I agree to waive all of that. I don't want to touch that. But I don't like all this language in here that is talking about our income or me waiving alimony, because what if I end up not working and then I find myself in this situation? So we start with kind of a base understanding and then really tailor it. I mean, it's tailored to the circumstances, and make it what the parties need for their circumstances.
I love that. And just like a note here, just as you come in, like with the full financial disclosure, that is something we as advisors can help with. That's something that we typically are keeping track of anyway for a client. It's just like when you go to buy a house or trying to get a loan, you need that financial statement. That's something that we help with. But I really loved what you said too about future planning and, working through that with titling and thinking, ahead, and just how important it is if you do have a prenuptial agreement in place that you're sharing that with the other people that you're working with, just so they know, so that the planning can be tailored around that and according to like what the intent and purpose is. So I like that a lot. And I love starting with the base. That's so much easier to like digest in the beginning, and then you can add on.
It's like you almost figure out what you don't want before you figure out what you do want.
Yeah, I like that.
Absolutely. And a lot of times we end up, so it depends on, again, the specific facts for the specific clients, but a lot of times we end up including schedules. So a lot of times when we're talking about maybe somebody's second marriage and one party's first marriage, or both parties' second marriage, or maybe one party has, substantial wealth and the other party doesn't. Catherine touched upon that consideration and the need for that exchange. And so it is very rarely that somebody is signing a prenuptial agreement that just says they don't ever get anything. Like, most of the time there's some bargain for exchange in this process. And usually, I find that our clients lean on us and our experience for that a lot of times. So we can, in that disclosure process, it's all in terms of relative wealth and negotiating, but we might say they waive alimony, but if parties are married for 5 years, one of the parties receives X amount. And if they're married, so sometimes we do schedules of distributions. But again, that ties back to, if you can plan on both sides right now, if you can plan and establish security and knowing that this is the end outcome, if this circumstance were to occur, it's a great way for the parties to know that. And again, another document that's great for financial advisors to have is that prenuptial agreement with that table, so that you all are at least aware of what's, coming down the pipe potentially.
Yeah. And I like to think of, in general, prenuptial agreements like a spectrum, right? And so LB's already touched on kind of the more all-encompassing prenuptial agreement of it would include, how every type of asset was divided, who gets what in the event of divorce. But oftentimes we have clients come to us on both sides, whether the business owner or about to be the spouse of the business owner, and they say, hey, this is literally the only asset I want to protect in the event of divorce. And so obviously then that prenuptial agreement's a lot shorter because it's just protecting that specific asset. And so again, it's a wide range, and we just kind of meet clients where they are and work through a type of document that really is just a living document that's going to grow with the parties throughout their entire marriage.
Well, that was another, I guess, consideration to think. I feel like it can feel so concrete when you are drafting legal documents or sitting down with an attorney, but what this looks like over time as situations change, how is that experience? If you get married and then 10 years down the line, life has changed and assets have changed in any way, shape, and form that you maybe did or did not expect, how does the prenup adjust to that, or how do you address that moving forward?
Yeah, are they easy to edit?
Yeah.
So I would say that we try to draft an agreement that will grow with the parties, right? Because you don't want parties, this is my personal opinion, you don't want parties coming in and constantly feeling the need to renegotiate their prenuptial agreement during their marriage. Like that's a cycle that like we don't want, right? But at the same time, we recognize that the documents are living, and that the parties' lives are changing. So it's a contract, but we provide terms where it would be modified or can be modified. And if it's going to be modified, it's going to be done in writing, pursuant to the terms of the prenuptial agreement. And so there are times where absolutely, situations arise that lead to people wanting to renegotiate terms of agreement, or maybe, somebody, wasn't an owner of a business, is now going to inherit a family business, and they just want to make sure all loose ends are tied up. And so they come back and they revisit that. But generally speaking, in terms of like the estate planning component that you all just spoke about, with the panel before us, that is something that is constantly revolving for people. And people will do that several times over their lives. So we try to build in, with respect to our prenuptial agreements, language that really leaves the door open on estate planning, where parties don't feel the need to come back and modify a prenuptial agreement just to go speak to an estate lawyer. We really want parties within their marriage to have the freedom to estate plan as they need. So that's an area that we really try to leave it open for the parties. But there are definitely situations, sometimes involving fault, sometimes not involving fault, where people come back to the table to try to renegotiate some prenuptial agreement terms.
But I think that's just such a good plug too, like you said, to use attorneys that in good documents, right? Like how important it is to have a good document that allows for some flexibility should it be needed, but also is drafted in a way that it can expand and build with you over time. So like,
I feel like that almost goes into like the implementation. So it's like, really, what does this look like in practice? If you do or do not have one.
Yeah, so the standard right is the assumption that no prenuptial agreement exists. And so in the state of Tennessee, that essentially just means if there's no prenuptial agreement, then you follow Tennessee law in dividing the marital estate. And so when looking at dividing the marital estate, LB's famous quote is, you define the pie before you divide the pie, right? And so in defining this pie, you look at what's separate property and what's marital property. Well, usually the assumption is anything earned or incurred during a marriage is in fact marital property, and then the courts have to divide that equitably. So where some separate property could come into play without a prenuptial agreement is if you inherit something and you keep it locked down where you don't put anything else in and it's strictly inherited funds, then you have a pretty strong argument that that should just be your separate property, and that is taken out of the pie equation, right? So that's kind of the, like I said, the assumption or the fallback we look at state law to determine how to divide property in the event of a divorce when parties do not have a prenuptial agreement.
What about gifts? Like if gifts are given during the course of a marriage, is that a marital property or separate property?
Okay, so in Tennessee, it starts off separate property, right? But it becomes very muddy in terms of how people do it. It's never, and we never get clean facts of it was a gift and they gave it to me and I put it in a separate account. I never touched that account. And it grew and it grew and it grew and it's so clearly my separate property. We always get
A gift letter that expressly says that. Yeah.
Yes, yeah. We always get it was, you know, a gift and we took $100,000 and we put it into our marital home and we needed an add-on. So we did this and this, or I put it into this joint account. And so it is very hard. It's not impossible but it's hard and within Tennessee law, and I would imagine most laws are relatively similar in this area. But again, within Tennessee law, it's not always that clean and it is often commingled to the point of becoming marital. That's where sometimes parties don't have prenuptial agreements, right? And you can't, we've talked about postnuptial agreements a little bit. Prenuptial agreements for us are way more preferred. There is the law is more favorable to prenuptial agreements. We look much closer at postnuptial agreements because the timing is after the marriage. And so I would say enforceability, we like prenuptial agreements way more than postnuptial agreements. But sometimes a party will come to us and they'll say, you know, I didn't get a prenuptial agreement and turns out I am going to inherit a bunch of money or I'm going to inherit this business. What can we do? And we can come together and try and draft a postnuptial agreement, giving some consideration to the other spouse to make the contract enforceable. That I would say that's probably not the same across all states. I would look specifically at whatever your state in, because again, postnuptial agreements are not nearly as treated as favorably by the law as prenuptial agreements. But if a party comes to you as wealth advisors, so maybe somebody who's listening to this and they're getting, you know, $1 million gifted to them or inheriting $1 million, that's a conversation where it's a great opportunity for the financial advisors and a family lawyer to hop on a phone and say, let's talk about the best way that we can protect this money without a postnuptial agreement and a prenuptial agreement. And obviously we don't do trust, but that's where we get estate lawyers in to try to protect that, or we can help. In each state, you're going to have lawyers who can help tell the financial advisor, here's what you're going to want to need to do with this funds. And here's how you're going to have to treat these funds to keep it separate, and really help you all populate some rules within your internal system to help keep that separate.
Right. We see that all the time, and we'll see beautiful legal documents that have been executed and maybe in place for a really long time. But the titling, for example, is something we see all the time of like, you know, have to make sure the assets really mirror those documents. Otherwise it almost becomes a moot point. So that's one of the things that when we do go through the Clarities process with clients, we build a net worth statement where we really take into account every piece. And we are often surprised, especially for clients who have been married for a long time, or it's an asset you purchased a long time ago, or not one that you use often. So it's making sure everything's titled correctly, I think applies the same way as it does to estate planning documents as it does here too. So,
yeah. And so I think the next piece of it was like, what is a valid prenuptial agreement? Like, what are the like main terms that need to be in the agreement to make sure that it is valid?
Yeah, so for our prenuptial agreement, if the parties have a prenuptial agreement, then obviously in the event of divorce, we're fighting for the validity of that prenuptial agreement. And if it is valid, then those are the terms within that agreement that we follow when dividing the estate. And so one of the main prongs that we like to tell clients when they are executing a prenuptial agreement with us is one of our main principles is title controls. And so that's just a really short little memo to help them remember those types of things when making decisions throughout their marriage, right? And so really that what that means, title controls, is we're setting the floor again. And so if a party places, let's say, their paycheck in a separately titled checking account, well, then that would likely be their separate property if we're operating under this prenuptial agreement, right? But in the event that they then place half of their paycheck in maybe a jointly titled checking account or a jointly titled marital residence, then that's when that becomes joint marital property, right? And so that's just kind of one of the slogans that we really like to emphasize with clients to help them remember that when they are living and growing with this prenuptial agreement throughout their marriage, that they have the flexibility to direct funds and other assets to either create separate property or create jointly titled property. And that's really just one of the mechanisms that we prefer to help this agreement really be alive, right, during the marriage.
Yeah. Absolutely. And then we've talked about that protecting the income portion, and we've talked about briefly about the alimony provisions. I mean, some prenuptial agreements are going to just flat out waive alimony, where neither party gets alimony. I mean, I would say 50% of my prenuptial agreements end up flat out waiving alimony because you have parties who are coming in with relatively sophisticated earnings on both sides, similar balance sheets, and so you end up just waiving it. And then sometimes when we waive it, I'll be honest, we always try to waive it to some degree, but then sometimes we build in like these alimony table provisions, which we often call just a division of the marital estate, where in the event of divorce, party gets X amount after so many years. And so, and then we usually do an attorney's fee provision. And I'll be honest with you, this is a very strategic provision. Earlier in the slide, it said good prenuptial agreements write divorce lawyers out of jobs. You know, like we want to draft an agreement. There are lots of people who want to get divorced, and so there's plenty of business. We enjoy helping parties who are serious about the security and wanting to name their rights up front, have those and have it so clearly stated that in the end, whether it's 5 years, 10 years, or maybe the document's never looked at, but when the document comes back to light, that attorneys are essentially written out of their job. And so this provision is strategic. It says that both parties usually will cover their own attorney's fees completely in the event of a divorce. And that really helps eliminate some kind of needless fighting that might happen on the back end regarding the validity of the agreement. That's the goal with that provision, is if parties are serious and they've been intentional about having this conversation and going through this process, the agreement should be enforced. And we want to put in provisions that assure its validity in the future. And so, yeah, that's kind of what that attorney fee provision is generally geared towards, is both parties being responsible. And we will include provisions within our agreement to that specifically say neither party, you know, the parties agree that this is voluntary and has been entered into fair and is equitable, and neither party will dispute the terms of the agreement, but it's not always that clean on the back end. So one thing that's not directly related to it, but why it's on my mind, I want to mention it because it's a great plug kind of for the generational aspect of this, and you all's role in that is this is a great point too for parties to make sure they're maintaining records. So a lot of parties, and you all will know, financial institutes a lot of times will only go back 5 years, and sometimes like a really good financial institute will go back 8 years with records. And so a lot of times when we on the back end are dealing with prenuptial agreements, it might not be till 5, 10, 15, 20 years. And so while that financial disclosure component is really helpful in us recreating what existed at that time, and again, a lot of times we wouldn't even be part of the original drafting, it's a great opportunity for financial advisors to make sure, sitting down with clients, for y'all to make sure that we're saving those statements and we're building a record to really help support the validity and enforcement of this agreement later. So
Yeah. And even if a client does not get a prenuptial agreement, it's super helpful to have those pre-marriage financial statements and bank statements or retirement statements, whatever they may be, just because you can still potentially carve out a separate property piece in the event of divorce. If you have a tangible statement with you says, hey, I had X amount in my 401k prior to the marriage, that should be my separate property. So that's a great tip, even if they don't enter into a prenuptial agreement.
Yeah, that's such a good point. And part of what we do is when working with the next generation, it can sometimes feel not superfluous, but maybe premature to pull together all of this information. But our thought process being, life is as simple as it's going to be right now. Let's get a good grasp, spend this time educating yourself on what you have, whether you're married or not, whatever may be, all it can do is help to inform you to be aware of what you have.
Absolutely.
So again, we are completely on
Yeah,
the same page there.
absolutely. That is a great reminder. And especially, I feel like we have a lot of clients whose children are getting married, and that is a great reminder to do that. And I think that like our hope is that, clients allow us the opportunity to meet with their kids and help them get all this together. Especially, I know when I was just getting married, I was like 23 and did not have a need for a financial advisor. We were both actually in school when we got married. We were both in law school. We had no money. Didn't think it was really important, but I like the idea of just setting that baseline, like just as a common practice when we work with our kids. I know we're going to go into just some of the conversation starters that I love. I really am going to enjoy this conversation about it because I know it can be so awkward to
Right.
bring up the conversation, and I'd love to get y'all's input on this. Sort of, y'all have already worded everything so well in this
So
conversation. I know that if I were to have met, I know clients meet with y'all and feel better immediately, but what are some of the best ways to get this conversation started?
So there are two arenas, right, where this conversation is happening mostly. It's that generational arena, and then it's that like direct with your spouse or your future spouse. And so those are two very different conversations a lot of time, right? But I think there's some overlap amongst the conversation. Like it's a delicate subject. It is, but I do think the taboo around it is we're seeing less and less of that. It's a conversation that you're going to approach with love, trust, and then understanding its relationship to finance, right? So I think for people in that next gen situation, it's a conversation that you want to plant seeds early on, I would say, and do it in a very trusted setting, right? So we talked about timing earlier. So you're not springing something on with somebody. Maybe you're planting seeds early, or maybe the seeds have already been planted. So it's not something that feels like last minute that's being brought down. I think there's a way to approach it with care versus control, right? Coming with that leading with the care side. And here's why. And again, all those things we talked about, the security, the agency, like the agency of somebody getting married, to be able to sit there and have these conversations, and make decisions about their life and their marriage and their finances. And then a lot of people I might not know this before they're listening to a conversation like this, but it doesn't have to be that all or nothing. Like, here's what we really are looking to protect. And here's, what will you just meet and have this conversation? And maybe it starts with a financial advisor, like you all, who they've already have that trusting relationship with. And then you all obviously work with the family law attorney in that area to try to figure out the best way to move that conversation forward. But I would just encourage people to not have fear around the conversation, to just go into it with good judgment. And again, love, trust, and going into it and then trying to guide it to that kind of shared opportunity security. So
Yeah.
Mhm.
And I like one angle I like to try to spin in is a sense of empowerment, right? And so to take ownership in not only your own financial planning and tools in the future, but to make it a team collaborative process. And so LB mentioned earlier, prenuptial agreements should not be this adversarial back and forth, screaming attorneys going at each other type of process. And so I think it's really an empowerment tool in order to understand where both future spouses are starting financially, and to have that financial disclosure, I think, is really helpful for people to begin planning what their marriage and financials look like. And really actually also from an ownership perspective, an angle of, okay, well, in the event that you all divorced, if you don't have a prenuptial agreement, well, you've got to revert back to whatever the state legislature says is going to be an equitable divide of your marital estate, right? And so why not take the opportunity again to empower yourselves and to be able to take ownership in whatever that settlement may look like, especially when emotions and tensions are a lot lower when you're excited about getting married instead of, in the middle of a divorce. So I think from an empowering standpoint can also be an effective angle to broach the subject for sure.
So I think our main takeaways are, don't be afraid to have the conversation.
Right.
That you can approach the conversation from a positive angle rather than a negative angle. I like to, it sets the floor, not the ceiling.
Love that.
Pay attention to state law. Obviously, this is very state law specific. If you move, does it matter?
Yeah, it's like if you get married in a different state. I know we kind of talked about this on the pre-call, some examples. If,
Yeah.
in Louisiana, for example, that has far different laws than Tennessee. Or
Yeah. Is there ever a reason to relook at it if you move?
So absolutely, if you all had a new client come to you who had moved from out of state, I think you would want them to have it reviewed. But a good prenuptial agreement that was drafted by lawyers in whatever state they are, hopefully has a provision that's a choice of law provision. So ours says Tennessee is the choice of law, and our clients can move wherever in the world, and they've contractually agreed that in the event of a divorce, prenuptial law in Tennessee is going to control that enforceability of that contract. It's when parties don't have the choice of law that states will handle it differently, and Tennessee is not favorable to parties who don't have a choice of law provision. They bring it into our state's requirements, and they set it aside pretty quickly in most situations, which is not what you want when you've already gone through the effort and difficultness of having these conversations and hiring a lawyer. You want that agreement to be enforceable. And so I would encourage, if somebody has a prenuptial agreement and they were thinking about moving, really looking at that choice of law provision to make sure it's drafted right.
Yeah. And so it's drafted, just want to confirm, it's drafted in the state that you're living in, even if you get married in a different state. So your marriage license.
Yeah. So our clients travel all the time to get married, right? And so yes, it's usually wherever they're both living.
Perfect.
Just another good, so last point, make sure you hire an attorney to help you work through this, someone who is reputable, who has experience drafting prenuptial agreements, postnuptial agreements.
We see sometimes, generalists sometimes in the law do exist.
Yeah.
But for something specific like estate planning for family law, you really want someone who has experience in this space.
Yeah. We have a story of working with a client who we came into the meeting. It was very interesting. The wife had asked us to come to her home to meet with her, said she was going through a divorce and she wanted to meet to discuss our services and what we did. So Lauren and I arrived. This was prior to Ellen joining the team. I hate that she missed this. So we walked in, and the client, her soon-to-be ex-husband, and an attorney were in the room. And they were like, we're negotiating the divorce right there at the table. We had never met them. I'm an attorney, so I was a little bit panicky. I'm like, I'm not representing you as a registered investment advisor.
I'm advisor now.
I'm not allowed to do, I'm not representing you legally. And so they began discussing the terms of the divorce. And one of the terms that the wife wanted was that if he remarried, that his new wife had to sign a prenuptial agreement before them getting married. And I'm sitting there thinking, and the generalist attorney's like, absolutely, we can put that in there. That yes. And I was thinking, well, I don't think you can add a provision to a contract that binds someone who has not agreed to this agreement to that. You know, like
contract.
I mean, I was like, I mean, you could put that in there, and but like you can't. Like anyway, it was this whole thing, and there were so many provisions in there that were like that I was like, I don't think this attorney drafts many divorce agreements. And so we had to go back after the meeting was over and be like, hey, I really think it's important that we get like an actual divorce attorney involved. And so I think sometimes people just don't realize how much experience plays into this. And like, y'all have seen a lot, you've learned a lot over the years and know like the common pitfalls and how important it is to hire somebody that like does this.
I wish I could say that was the first time I've heard of people considering prenuptial agreements during the divorce process. But
yeah, the new wife.
Some people start the conversation way earlier than me.
Yeah.
Timing
He
timing is
wasn't
important.
Is there anyone new? Not yet, but that's okay.
Yeah, but-
It's a red flag if that
Yes.
conversation is being had that early. So
yeah,
timing is important, but we don't want them that early.
not that early.
Not
Not
that
that early. So thank y'all so much for your time.
Truly, we
This
so
is-
appreciate. And for any clients who are on the call or any even if you don't work with us yet, if this is something that's on your mind, we are happy to help put together again all of the pieces that really set this into motion, and make sure that when you meet with an attorney like LB or Catherine, you are fully ready to participate in this and be aware.
Yeah, absolutely.
Awesome. Well, thank y'all so much. I think our next session will start in about a little under 15 minutes. So you can bathroom break.
Thank y'all for having us.
Thank you.
Thanks, guys.